Welcome to Learn by Choice. So in this video we are going to talk about how to make the will online, what are the various types of wills available, and also some brief about will and which may be of very help to you so while transferring the property or assets in your name to your children. So the assets of a person, it may be a physical assets or it may be financial assets or it may be property or a house, and post your death you can decide in what way these assets have to be transferred. So you can transfer it to your son or daughter or to your wife or to the orphanage. So this transfer of assets to these people can be decided by writing a will, and these people are called right heirs. If you don't write a will and it is called intestate, and the property will be decided according to the law of succession, and Indian Succession Act 1925, it decides how the property have to be transferred in case there is no will by the owner of the properties. And all these transfer of properties, everything is part of the financial planning. So under the financial planning, so it may be the subclassified under succession or estate planning. So one thing you have to keep in mind, so the assets of a person, he can transfer through will only the self-earned assets. So joint assets you cannot transfer. For transferring the property or the assets to a person, so eligibilities are, so the person should be 21 years old and should be of sound mind. And the family should follow the simple family structure. It should not be complicated. No ancestral property, the property acquired by him from the ancestors, from the predecessors, and also the property not in the single name, which is in the joint name, can also not be transferred. So as far as Hindu religion is concerned, wherever there is no will, the property or the assets is transferred by under Hindu Succession Act in the year 1956. So online wills, there are a lot of service providers offering this facility. If you want to avail online wills, you have to go to the company's portal and the service provider's portal, and you have to register your name and provide the data and also your physical assets and also your financial assets, what you want to distribute. And you have to select a person as an executor, and it should be a trusted person. And this person role is, once the death happened, then he has to transfer the property to the legal heirs or to the person to whom the property you want to transfer. So in the will you have to specifically write the specific bequeath and in the ratio or the number of items or exact nature of items which you want to transfer. So then you draft the will, and also you can review it, and also you can finalize it before making it the final will. Registering the will is not mandatory, it is only optional. So many people are confused about the wills and also nomination. So both are two different set of things. In will you are actually transferring that ownership of the property to a particular person. Normally nomination is applicable in financial assets, wherein you nominate a person to receive the money in case of your death, but the nominee's role is only a trustee. He has to receive the money wherein his name is occurring, or he has been nominated. His role is to receive the money and transfer to the eligible or the legal beneficiaries. And whatever will you are writing, this will cannot become effective before the death of the person. So the death has to occur for the will to be made effective. The will of a person has to be filed after the death of the person within 3 years in a court. That court is called probate court, and the court, after scrutinizing the will, and they will issue the letter of administration accepting that will. So in case of the religions, Muslims and Christians, there is no probate for the will, and whose role is to submit the will to the court. Yes, it is executor. So that is why the person who wishes to transfer the property has to identify the most reliable and the trustworthy person as an executor. And in case of online will service providers, there is no third parties, then there is no lawyer, and there is no expensive fee also. For example, nowadays the lawyers, they are writing the will, they are helping the people to write the will, and the lawyers, they also charge exponentially. There are certain lawyers, they charge in percentage of the assets involved. So that is also huge. So to avoid all these complications, these services provided by the online will service companies can be very effectively utilized. So post will and before death, yeah, he can review or revoke. For example, the will he is writing to transfer a particular property, but before his death, and he can dispose the property, he can sell it. And codicil, codicil means, for example, he is writing a will that is also registered, maybe even though registration is optional. But if he wants to add something, he can put as a supplement to the particular will. That is also possible. And there are certain exemptions which I told you. So the joint property or the ancestral property, and in insurance policies, you are naming a particular person. So those insurance benefits you cannot write as part of the will. And many people think that automatically in my death, my property will be transferred to my spouse or children. That is not going to happen. So there are some misconceptions. That is why people are not resorting to writing a will. For example, I am not going to die. I am going to live permanently. That is also not true. And the will, I have nothing, and the will is only for the rich people. That is also not true. Even though you have little, that can be transferred through will. And the family, after my death, I have some property. My family members won't fight for this. They will amicably settle among themselves. That is also not going to happen. And people think that the lawyer services, I should take the legal services provided by the lawyer for writing a will. That is also a misconception. And the assets are auto transferred to my spouse. After my death, my property, everything will be transferred to my spouse. That is also not true. So the person who is transferring the property or assets to the other person, and through a will he is transferring to the legatee. So these are all the technical terms. This may be useful to you. So the testator is transferring his inheritance to the legatee. So pre-will, and while writing the will, you should know the various types of wills. One is testamentary. Testamentary is that normal will. You write and you get it witnessed. 2 witnesses very mandatory. Then either you keep it in a bank locker or you keep it in safe custody. That's a normal will, testamentary will. And holographic will, for example, in the last minute you are writing the will where you are not getting the witness. So that the will without any witness is called holographic will. And there are some occasions wherein the wills cannot be written. So you orally tell something before the death. So those things are oral wills. And there is a will called mutual wills. In the mutual wills, there are 2 persons involved, for example, husband and wife, and they are writing the will to transfer the joint property to their son or daughter's name. And in case of the one of the spouse death, the other spouse has to transfer the property to their son. So the main aim of this mutual will is that in case of one of the spouse only surviving, and if that spouse marries to the other person, that the other person who is coming and marrying that other spouse, the remaining spouse, should not claim ownership of the property. So that's the aim of the mutual wills. And there are some points which has to be kept in mind. The beneficiary, cannot be the beneficiary and also the witness. And will, maybe it's not that you have to write in a stamp paper, it can be in a plain paper also. There are multiple wills as possible. For example, you write a will today, after 2 years you write, and that whatever will you are writing, it's a last moment, at the last will, latest will is only considered as the valid will. And some people are also writing the will and also recording the message. That is also they are doing. It will add further authenticity. And whatever amount or whatever assets you are writing in the will, please try to maintain the privacy. And the beneficiary, there are some occasions wherein you are transferring the legatee may predecease the testator. That is also possible. And so the aim of this video is no one should die intestate. Be aware what are the nuances of the will. And as I told you, insurance benefits cannot be settled through will, and it should be as per the policy details. And there are three major players as far as the will services are concerned: EC will, e-will, and online will.